In the John Magnier and Barron estate case, I've made a video there about the statutory requirements for the enforcement of a contract for the sale of land. In other words, that there must be a memorandum or note in writing. Have a look at that video. It'll set out precisely what the statutory requirements are, and the statutory requirements go back to the Statute of Frauds Ireland Act of 1695. So the law in this area, in terms of a written memorandum or note concerning the sale of a property, in order to be enforceable, you need a written memorandum or note. However, there is an equitable doctrine of part performance, and that essentially serves as an exception to the Statute of Frauds Ireland 1695 Act, which generally requires for the sale or other disposition of land to be in writing and signed by the party against whom the enforcement is being sought. So that would be, well, in this case, in the Magnier Barron estate case, against the vendors. However, where one party has partly performed an unwritten agreement in reliance on it, equity may intervene to prevent injustice. So it may be the case that if there isn't written evidence or written note or memorandum of this deal, Magnier may be relying on this equitable doctrine of part performance, where he claims that he has partly performed the unwritten agreement, but he will say obviously that there was an agreement. So the statutory background, just to be clear about it, is the Section 2 of the Statute of Frauds Ireland Act of 1695, and it says that no action shall be brought upon any contract or sale of lands unless the agreement shall be in writing and signed. So this provision would ordinarily render a verbal agreement for the sale of land unenforceable. The agreement might be valid but is unenforceable. However, the doctrine of part performance provides an equitable exception to this statutory requirement. Irish courts, following the equitable principles from English Chancery, have recognised part performance to override the statute in certain circumstances. What are those circumstances? To invoke part performance, the plaintiff must show A, the existence of an oral agreement. There must have been a clear oral contract for the sale or disposition of land. B, acts unequivocally referable to that agreement. The plaintiff must have done acts that clearly point to the existence of that contract, acts which could not reasonably be explained other than by reference to the contract. And examples of such acts would include taking possession of the land, making substantial improvements or expenditure on the property, payment or acceptance of a significant part of the purchase price, executing documents such as planning applications with the owner's consent. So they would all be acts which you are saying which must be unequivocally referable to the agreement that you claim. And then C, you must prove reliance and detriment. The plaintiff must have acted to their detriment in reliance on the contract, and it would be unconscionable to allow the other party to rely on the statute to avoid the contract. In this case, if Mr. Magnier is relying on part performance, the equitable doctrine of part performance, he may have a difficulty in this particular leg of proving his case. In other words, reliance and detriment. How is Mr. Magnier going to show he has suffered detriment? Somebody else may have swooped in and bought the property for more money, Mr. Regan for example, but what detriment has Mr. Magnier suffered? So that could be a problem. I don't know, we haven't seen all the evidence, it's early days yet, but that is the situation. There are 3 Irish cases, key cases. McCarran versus McCarran, that's a Supreme Court decision. It confirmed the continued applicability of the doctrine in Ireland of part performance and restated the requirement for acts to be unequivocally referable to the alleged agreement. Another case is Corrigan versus O'Neill. This is a 1946 case. It established that mere payment of money without more is not sufficient to constitute part performance. So just handing over money is not enough. And then there's O'Connor versus Murphy, a 2007 case, High Court. It found that part performance where the plaintiff had made significant renovations and was allowed to enforce the agreement. So in that case, the plaintiff had made significant renovations and presumably spent money in those renovations, and presumably the vendor in that case stood back and let the plaintiff make the renovations. What are the modern implications? The Land and Conveyancing Law Reform Act of 2009, which I referenced in the other video that I did about the statute of frauds and about the statutory requirements for the enforceability of a contract for the sale of land, it did not abolish or codify the part performance doctrine, so it remains, part performance remains part of the equitable jurisdiction of the Irish courts, and practitioners, that solicitors, must still rely on equitable arguments where formal requirements of written contracts are not satisfied. It is possible, I'm not saying it's the case, but it is possible in this case that the formal requirements of written contracts, as per the Statute of Fraud 1695, are not satisfied. If that's the case, then the reliance on this equitable argument of part performance is open to Mr. Magnier, but he does need to prove A, the existence of an oral agreement, B, acts unequivocally referable to that agreement, and C, reliance and detriment. And I think myself, so far on the evidence, but only so far, reliance and detriment will be the problem for Mr. Magnier, because I can't see what detriment he suffered apart from disappointment, and that's not something that the law generally makes provision for, quite frankly. So to be clear, and in summary, in Ireland, while contracts for the sale of land must be in writing under the Statute of Fraud 1695, equity may enforce an unwritten agreement if the claimant shows A, a clear oral contract, B, acts of part performance that are unequivocally referable to that contract, and C, detrimental reliance on the contract. This doctrine, this equitable doctrine, operates as a shield against injustice, not a sword to bypass statutory formalities. Hope you find the video useful. If you do, hit the thumbs up button down below, and if you're interested in buying a property or selling a property, I give away a free report on my website, businessandlegal.ie. I leave a link underneath this video on my YouTube channel. You can get the report for free by signing up, giving your email address, sign up, and you get the free report. Thanks a lot.